Welcome to SGT Times Explainer. I am Mehak Bhardwaj. Today, we'll discuss Data Protection Bill, its scope and right to privacy rules. On Thursday, the government plans to introduce the Digital Data Protection Bill in Parliament to make entities such as internet companies, mobile apps and business houses more accountable and answerable for the collection, storage and processing of citizens' data as part of the right to privacy. The bill's first draft was introduced in November and went through many rounds of public input. A second draft was created, taking into account the input gathered during these consultations and was then subjected to interministerial deliberations. On July 5, the Union Cabinet approved it. This bill is an important part of the government's broader framework of technology regulations, which also includes the Digital India Bill, the Indian Telecommunication Bill of 2022, and a policy governing non-personal data. Let's talk about Digital Personal Data Protection Bill 2022. The bill would have authority over digital personal data processing in India. This comprises information gathered online or offline and afterward digitized. The bill would also apply to data processing outside of India if it includes the provision of goods or services or the profiling of persons in India. Personal data can also be processed for authorized reasons with the individual's agreement according to the bill. Consent may be implied in some circumstances. Data fiduciaries are responsible for ensuring the accuracy and security of data and deleting it once its purpose has been met. According to PRS India, the bill offers individuals certain rights, including the ability to access information, request changes and deletions, and seek redress for concerns. In defined situations such as national security or public order, the government may exclude its agencies from certain sections of the bill. The government will establish the Data Protection Board of India to ensure compliance with the bill. Exemptions given to the government for data processing on grounds such as national security, on the other hand, raise concern about potential violations of the right to privacy. The bill differentiates between private and public bodies in terms of permission and storage constraints, which violate the right to equality. The federal government will set the makeup and operation of the Data Protection Board of India, raising concern about its independence. The bill does not include provisions for data portability or the right to be forgotten. Before processing a child's data fiduciaries must seek verified consent from the legal guardian. This regulation may have repercussions for online anonymity. Now, is this a check? On Thursday, the administration confirmed that the bill will not be a money bill, but rather a regular bill. Manish Tiwari, the Congress leader, has previously queried how the Digital Data Protection Law could be classed as a financial law and stated that it should be treated as a normal measure. How did the Digital Data Protection Bill suddenly become a financial bill? It should be treated as a regular bill and referred to a JPC, Joint Parliamentary Committee. Again, he tweeted, after the Supreme Court determined that the right to privacy is a basic right, work on the data protection law began. The government withdrew the Personal Data Protection Law, which was initially introduced in late 2019, in August of last year, and released a fresh version of the draft bill in November 2022. The draft law drew criticism for granting the government the authority to exclude companies from certain provisions of the bill. Now let's discuss its key features. The bill would apply to the processing of digital personal data in India, whether obtained online or offline and digitized. It will also apply to the processing of personal data outside of India if it includes the provision of goods or services in India or the profiling of persons. According to PRS India, personal data is any data that may be used to identify an individual, and processing includes actions such as collection, storage, usage, and dissemination. Personal data can only be processed for authorized reasons with the agreement of the subject. Consent must be sought through a notice that describes the data to be gathered as well as the purpose of processing. Individuals can revoke their consent at any time. Consent is presumed provided in certain situations where processing is required for legal duties, state provision of services or benefits, medical crisis, employment objectives, and defined public interest purposes such as national security and fraud prevention. Individuals under the age of 18 will be given consent by their legal guardians. Let's talk about data principals' rights and duties. Data principals have the right to access information about processing, request correction and erasure of their data, appoint someone to exercise their rights in the event of death or incapacity, and seek redress of grievances. Data principals must also follow specific rules such as not filing fraudulent or frivolous complaints and giving correct information. Violation of these responsibilities may result in sanctions. Now let's talk about the obligations of data fiduciaries. Data fiduciaries, or entities that determine the purpose and methods of processing, are responsible for ensuring data accuracy and security. They must put appropriate security controls in place to avoid data breaches and notify the Data Protection Board of India an impacted person if one occurs. Personal data should be erased after the processing purpose has been met, unless retention is required for legal or commercial reasons. Government entities are exempt from the storage limit requirements. Let's talk about the personal data sent outside India. The federal government will notify nations to whom data fiduciaries may send personal data. Such transfers will be subject to the terms and limitations specified. Exemptions include, except for data security, some rights of data principals and responsibilities of data fiduciaries may not apply in specified instances such as the prevention and investigation of offences and the enforcement of legal rights. Certain activities, including processing by government bodies in the interest of state security and public order, as well as research, archiving, or statistical reasons, might be exempted by notice by the central government. The Data Protection Board of India will be established by the national government to oversee compliance, levy penalties, instruct data fiduciaries in cases of data breaches, and handle grievances. The board's membership selection method, terms and conditions of appointment, and removal mechanism shall be determined by the government. Now let's talk about the fines. The bills provide fines for a variety of violations ranging from up to Rs 150 crore for failing to meet commitments relating to children's data to Rs 250 crore for failure to install security measures to prevent data breaches. Following an investigation, the board will issue fines. That's all for today in SGT Times Explainer. Thanks for watching.